Good morning. My name's Jane Fielding. I'm head of the Employment, Labour and Equalities team here at Gowling WLG in the UK, and I'm delighted to welcome all of you to our webinar this morning on managing sickness absence. I'm joined by Emma Buffton, who's one of the principal associates in our team and who's recently returned from a 6-month secondment at a client where she's regularly been advising HR and the business on these sorts of issues. Now, sickness absence is a perennial challenge for employers, resulting in loss of productivity, impact on staff morale, time, cost, etc. And you might have thought that during the pandemic, days lost to sickness absence would have gone up. But in fact, according to the figures from the Office for National Statistics, the average number of days per employee per year lost to sickness actually went down from 4.4 in 2018 to 3.6 in 2020. Now that could be for a range of reasons. It could be people living healthier when working from home, more exercise, better diet, lack of mixing, or it could be a lack of reporting due to fear of redundancy, perhaps. But whatever the reason, as we all begin to mix more and people are bringing their staff back to the workplace, perhaps for the first time, we're seeing more sickness issues coming to the fore. And so we thought it was a good time to do a refresher on this topic. So what we're going to cover on the agenda is a brief view of the legal landscape, which Emma's going to give, policies, training and monitoring and how important those are. And then with reference to some scenarios, which we've given a COVID flavour, we're going to look at how to manage short-term persistent absences and long-term absences. Now we're going to speak for about 30 minutes and then we'll leave time at the end for some questions before we close at 11:55. Now, if you could use the Q&A function, which is, if you're not familiar with Zoom, at the bottom middle of your screen. If you just type a question, if you have one, into there, then we'll keep an eye on those as we go along. And as I say, we'll try to get to as many as we can before the close. If we don't answer your question, and you've put your name on it rather than anonymous, then we will follow up with you afterwards, so you will get a reply. If you've got any tech issues, then if you also use the Q&A function, then Joy Litchfield, who's helping us with the tech today, will try to sort that out for you. And at the end, we will send by email a feedback questionnaire, which would be really grateful if you could fill in. We do read them and we do take account of them going forward. So I will hand over to Emma.
Thanks, Jane. So if we start off then by looking at the legal landscape, I think it can sometimes be forgotten that there's no actual statutory right to take time off for sickness or injury. In most cases, though, employees will either have that written into their employment contracts, and that's because of Section 1 of the Employment Rights Act, which requires terms and conditions on sickness to be contained in either the contract or some other document or policy that's reasonably accessible to the employee. Or it's very likely to be arguable that ought to be an implied term that the employee is not required to work if they're not well enough to do so. Whilst there's no express statutory right to sick leave, there is an express statutory right to sick pay. So all employees, if they meet the eligibility criteria, are entitled to statutory sick pay for up to 28 weeks if they're absent on grounds of ill health or incapacity. And the current rates for that are £96.35 a week. Ordinarily, and I'll come on to explain some exceptions to this, this is available only after the employee has been absent for 3 consecutive days, so it's available from day 4. If the employer chooses to do so, they can offer to enhance statutory sick pay, but if they're going to do that, then that should be clearly set out in writing. And also that should cover, for instance, things like whether or not that company's sick pay is discretionary, and also whether or not any statutory sick pay is going to count towards company sick pay. Now, the COVID pandemic has led to a series of changes to this statutory sick pay regime, and those came into force in March last year. These are, as you would imagine, technical and complicated, but broadly there are 3 changes. The first is that employees who are self-isolating or shielding are permitted to access statutory sick pay. And there's also been a removal of the need for waiting days in COVID-19 cases. So that requirement to wait 3 days before you can access statutory sick pay has gone. And that's for policy related reasons, that the government didn't wanted to make sure there weren't any barriers to doing the right thing and encouraging employees to self-isolate. The final change is that those employers who have fewer than 250 employees are entitled to recover from HMRC up to 2 weeks SSP per employee for COVID-related absences. Whilst technically there doesn't appear to be an end date for these regulations, there was initially, and that was subsequently removed, it seems likely that these provisions will expire around about the same time that other employment COVID-related regulations will expire. So both the self-isolation regulations and the Coronavirus Act itself both expire on the 24th of March 2022. So it seems likely that the statutory sick pay regulations will be around until at least then. Next slide, please, Joy. So there are a number of pitfalls and potential claims for employers to negotiate when they're navigating, managing that sickness absent process. Now, for timing reasons, we aren't going to be able to look at all of these in any great detail and to delve into the law and tests on them. But what we wanted to do at this stage was to flag them to you so that they are on your radar. And so the first of those that you'll see on the slide is unfair dismissal. And that's both ordinary unfair dismissal and also constructive unfair dismissal risks when managing sickness absence. So if the employer were to unreasonably refuse to permit their employee time off if they're ill, and that employee were then to resign and to claim a fundamental breach and breakdown of the relationship, that could give rise to a constructive unfair dismissal risk. And also if the employer were to decide that the employee's levels of absence were no longer tolerable and were then to move to terminate that employment, that could give rise to unfair dismissal risks. For these claims, employees need to have 2 years service and to mitigate against the risks, because capability is one of 5 fair reasons for dismissal. The employer must make sure that it follows a fair process, and crucially, that any decision is reasonable in all the circumstances. So dismissal really should be the last resort. The second potential pitfall on the slide is discrimination. Now, of course, not all disabilities lead to increased absences, but if an employee who has been absent from work for a reason related to illness might be protected by disability discrimination under the Equality Act. And there's no minimum qualifying length of service and also no upper limit on compensation in the same way there is with unfair dismissal claims. If employers are in any doubt on this, it's best practice to err on the side of caution and treat the employees if they are disabled. The third potential pitfall is breach of contract, and that's particularly an issue for employers whose policies and procedures are contractual, because if they're not followed to the letter, then there is a breach of contract risk. There's also a risk of health and safety and working time regulation risks, and that's really risen to the forefront since the pandemic. It used to be very rare for us to see Section 100 Employment Rights Act related claims. So those are claims for automatic unfair dismissal for health and safety related breaches, but we've now seen much more of those. And also with the rise in remote working that followed as a result of the pandemic, many employers are continuing to offer that flexibility to employees. And so they're going to need to be alive and mindful of the impact that these different working patterns might have and the possible increases of stress that can bring for employees trying to balance home and work life, and also that can lead to increased working hours. Fifthly, there might also be a rise in personal injury claims. I mean, the obvious one being if an employee sustains an injury whilst at work, but also we've seen a rise in stress-related claims if they say that that particular illness has been caused by work or the workplace. And the last one, or the last pitfall to flag before I hand back to Jane, is that as well as PR damage, managing absence can also be an employment relations issue too. So Jane mentioned about absence having an impact on employees, colleagues and their morale if they've got to pick up the slack. But it's also an opportunity for employers, if the absence management is managed well, for employees to have confidence that they're working in a supportive and collaborative organisation. Okay, I'll pass over to Jane.
So having a policy to manage sickness absence, training your managers on it and keeping track of the absence is really key for two reasons. Firstly, planning for the worst, so you're building your defence to a tribunal claim in the event that you end up with one of those and it doesn't remain internal. And secondly, you're sort of hoping for the best, you know, with a good process and support to the employees, hopefully they can improve their attendance and or performance at work. So a procedure is something that a tribunal, certainly in any organisation of any size, will expect to see, but it's also important for employee relations perspective, so that employees can see that there'll be fairness between them. And a good policy can help managers understand what their role and responsibilities are, and it allows employees, on the other hand, to sort of manage their expectations about how their sickness absence will be handled and what they can expect to be looking at. So many of you will have a policy already, I expect, but just as a reminder, or if you don't have one already, as a minimum, you should have the following in there. So setting out what the obligations are on employees to report their sickness absence and what evidence you're going to require from them of the fact they can't come to work. You're also going to have to put in there something about sick pay. So as Emma said, that could be statutory or company sick pay. And that might also be in the employment contract, but it's worth having it in the sickness absence policy as well. Really important and quite often forgotten to be implemented in practice, but you should have it in your policy, are return to work interviews. So when somebody comes back, sometimes it's very easy for the line manager to think, right, well, job done, they're now back working. But it's really important that they remember to have that conversation with staff when they're returning. The policy should set out the different processes for managing short-term persistent absences and long-term absences, which we will look at when we come on to the scenarios in a little while. And finally, it should make clear what in what circumstances you might ask employees to go for a medical examination or provide further medical information about their condition. In terms of training, so line managers are very often going to be the first sort of line of contact for staff. That they're the ones who are going to receive the sick calls. They know their staff best. They know and understand the impact on the team if somebody is going to be off. So it's really important they understand your policies and procedures so they know what to do when they're in this sort of situation. Now, obviously, HR and in-house legal can help, but as I say, the primary responsibility for managing this is going to fall on the day-to-day line managers. And the training should not just cover the process, but it should also cover the need to deal with these sorts of situations with a degree of empathy and humanity. Now, it may sound odd to have to point that out in training, but I'm sure we've all seen situations where it comes to us when it's all gone wrong, and we look back at how it started and think, well, if only the manager had been slightly more sympathetic to begin with, then we may not have ended up here. So support from managers can be a really positive experience, and it can really help resolve the situation. So it also is important that managers understand at what point they can be talking to the employee about getting some medical evidence and getting some more information about what the condition is that's keeping them off work. And particularly if it's a short-term persistent absence situation, they need to understand at what point it's appropriate for them to say to the employee, well, look, you know, are you actually getting some medical advice and some help with this? Because there might be an underlying issue that could be addressed and that could see you delivering a better performance. Now, one thing I wanted to flag here is the training absolutely needs to cover the manager's obligations under the GDPR, the data protection obligations, because wherever you're dealing with health information, that's special category data under the GDPR. So there are extra safeguards in terms of processing it. And that's particularly important where information might be being shared between departments, so between the managers and HR, for example. And in terms of monitoring, this is really important both at an organisational level and also in terms of individual cases. So organisationally, having the data about your sickness levels will help you track the impact, the cost of that absence, but also to see if there are any patterns in where the absence is occurring and what type. So it might be if you have a particularly high level of absence due to stress in a particular team, it could be an indicator that team is under-resourced, or it could be an indicator that it's being poorly managed. Perhaps there's some bullying conduct going on there. So it helps you dig down deeper and try to resolve the issues at an organisational level. Again, you need to be very mindful of GDPR requirements, even if you're doing it at an organisational level. The information might not be truly anonymous, depending on the size of the teams and the seniority of the people involved, for example. And on an individual level, you really need to have a good paper trail of what you've done in terms of interacting with the employee, as well as the actual absences themselves. As I said, a tribunal will expect to see this when they're looking back at how the situation's been managed. They will want to see contemporaneous evidence of that. So it's really important that any interactions, whether it's a meeting in the workplace, a home visit, telephone calls, WhatsApp messages, whatever it is, that they are all properly and accurately recorded. And of course, on the sort of proactive side, having a clear record of the interactions will also make it easier, particularly if you've got reminders of what the next thing to do is, to actually manage it live at the time. So a more proactive approach. So I'm going to hand over to Emma now.
Thanks, Jane. So for this next section, we're going to launch into a couple of scenarios on short-term and persistent absences to try and bring this area a little bit more to life. So this is the first of our scenarios, and it's a scenario where you have an employee who's persistently off with short bouts of absence, which appear on first blush to be unconnected, and what you do in those scenarios. I think there can sometimes be some skepticism about the reason for someone's absence and it being genuine, and that's particularly the case for short-term persistent absences. Employers do need to, though, be careful about making assumptions and jumping to conclusions based on a perception that an employee is never there. And that's one of the reasons why recording absences is so important, not only to see if there's a pattern, but also for identifying if any of those reasons are linked. And employers, when they're looking at this, should be looking at the pattern over a sensible period of time, because that's going to help build up a reliable picture of that individual's absence. And a good way of doing that is to use a calendar showing absences as against attendance. Of course, making sure that when you're looking at the absences, you aren't including absences of a different nature, such as somebody being off a holiday or family-friendly leave. But that should help identify if there is a serious problem. And after analysing the evidence over a period of time, the next step's then going to be to speak to the employee to gather further evidence and understand a little bit more detail about what the reasons for their absence might be. Of course, you need to be mindful, ensuring compliance with policies and procedures when you're doing this, as Jane's already mentioned, and that's going to be even more important if those policies and procedures are contractual. But short-term absence policies generally do involve a certain number of absences then going on to trigger when a return to work meeting will be held. And employers should think carefully about what those triggers will be to make sure they're capturing not only continuous periods of absence, but also those persistent and irregular absences too. But even if that formal return to work meeting hasn't been triggered, that doesn't stop the line manager having an informal wellbeing catch up with the employee if there are concerns. So depending on what the employee says, and it might be that there's a conduct or a capacity issue, if there is a capacity issue, then you'll want to investigate the medical issue through contact with that employee's doctor or with occupational health. And it may be that you need more specialist advice depending on what the opinion of that GP or occupational health is and how conclusive it is. Don't be tempted to rely on old occupational health or doctor's reports because the position may well have changed. But what you're really trying to establish with the medical evidence is what's the nature of the condition? Are the absences connected? What level of absence can be expected in the future and how long is it expected to last? You'll also want to explore what steps can be taken that might reduce the risk of the employee's absence levels. And when you get that report back, don't delay on acting on it. What you don't want then is for that report to then become out of date. But on the flip side, you don't want to be acting too quickly before you've had the report. And the second element of this scenario is what happens if those seemingly unconnected bouts of absence turn out to be connected symptoms of some underlying mental or physical health issue. Well, I think then if the evidence suggests that there is an underlying health issue, you want to understand from either the GP or occupational health if there are any reasonable adjustments that you should be considering. And that's because for disabled employees, reasonable adjustments are a legal entitlement. But even if that employee doesn't have a disability, there may well be strong duty of care or employee relations reasons for seeking to accommodate that if at all possible. If the employer has given serious consideration to the alternatives, including looking at things like changing working patterns and redeployment, for example, and if the medical prognosis is that that absence is likely to continue for a seriously disruptive level and a considerable period of time, then it may be fair to dismiss. But before dismissal, there should have been appropriate escalation through warnings. And that's one of the key differences between short and long-term absences that Jane's going to come on to talk about in a few slides' time. If that employee is dismissed and a process has been followed, then the employer is going to need to demonstrate that any unfavourable treatment arising from that employee's disability, if they've got one, is justified as a proportionate means of achieving a legitimate aim. And examples of such justifications might include the nature of the work and the impact of that particular employee's absence on the business being such that it justifies it. And you can see how that might arise in smaller organisations if, for instance, you've got the managing director off with persistent short-term absences. It's going to be more difficult to justify, and a much more careful balancing act will need to take place for larger organisations where the employee might be at a mid-level or junior level and where there are a number of others doing the same job as that individual. So if we move now then on to our second scenario, and this is a scenario where an employee catches COVID, but the only reason they've caught COVID is because they failed to follow health and safety measures that their employer has put in place. And what should you do in that scenario? Well, there are really two elements to consider here. So the first of those is the COVID-related sickness absence. And the second is the employee's failure to follow the correct measures. So if we look at sickness absence first, if the employees told their employer they have COVID, then the starting position is they must self-isolate for 10 days. That means they mustn't leave their home or the place where they're self-isolating, even if they're feeling well enough to. If that individual were to come into the workplace, then both the employer and the employee could face penalties under the self-isolation regulations. And the levels of the fine there are between £1,000 and £10,000. If the employee is unable to work or unable to work from home, then they'll be entitled at a minimum, if they're eligible, to statutory sick pay. And as I mentioned earlier, that's available to them from day one. If they are absent, then again, the employer should be looking to record that and also the reason too. It may be, though, that the employee is well enough to work and that they can work from home. And in that case, it would be prudent for the line manager to make sure that they are continuing to check in with the employee whilst they're off for duty of care related reasons. So of the two, that's the more straightforward process and would usually be dealt with under a sickness absence policy. But what happens if the reason the employees caught COVID is because they've failed to follow health and safety measures that their employer has put in place? Well, that may well trigger conduct and also health and safety policy breaches. What we have had is the recent case of Kabilis and Kent Foods, and that was an ET first instance decision, so it won't be binding on other courts. But it is interesting to see how the tribunal applied the law in this case. And it's also useful for employers who have put in place those health and safety related measures and then have staff who have gone on to ignore them. So on the facts of this case, the claimant was a delivery driver and he was required to attend the customer's site to deliver goods, and that customer required him to wear a mask. In his employee handbook, it required him to obey all customer instructions regarding PPE requirements. And he refused to wear the mask and had no exempted reason for doing that, and so was banned by the customer from their site. An investigation took place and the claimant was subjected to disciplinary proceedings and ultimately dismissed. Now, when the tribunal looked at this, it considered on these particular facts that because there was no other job that this individual could do, and this key customer had refused to permit the employee to work on their site despite numerous attempts by the employer to persuade them to rescind the ban. And there was also a requirement for all employees in the organisation all employees who were doing the same role as Mr. Kabilis to work for that particular customer. The tribunal was able to find that there was no unfair dismissal in this case. So I think the key takeaway here is that whilst dismissal may have been fair in this case, whether it's going to be fair in others will depend on the facts and the seriousness of the breach. Being dismissed, for instance, for accidentally failing to follow a one-way system is unlikely to be a reasonable response. But if, on the other hand, the employee has come into work when they've got COVID, then clearly that's at the other end of the spectrum. What will be important is that the employer has a genuine belief in the misconduct, that they've carried out a thorough and reasonable investigation, and that any disciplinary sanction up to dismissal is reasonable in all the circumstances. Okay, I'll pass back to Jane.
Thanks, Emma. So long-term absences. I think the first thing to say is here, what do we mean by long-term? So in the absence of somebody having a serious accident or going in for a serious operation, which is clearly going to take them out for weeks or possibly months, and you can plan for that to some extent, we recommend treating anything as long-term if the employee's been away for 10 working days. Now that may sound quite short, but actually the sorts of things, the sort of common colds, flus, stomach upsets, etc., really should clear up within that time. And we often see situations go wrong because the issue hasn't been addressed early enough. It's not, I guess, like wine, it doesn't improve with age. If somebody's off sick, then you need to understand why and what you can do about it. Now, in any long-term sickness case, you also need to be mindful of the fact that the employee may be disabled. That may be the reason they're off sick. Although, of course, just because somebody has a disability, it doesn't necessarily mean that they're going to have higher levels of sickness absence at all. It very much depends on the nature of the disability. But you need to understand that, and you need to understand whether they have an existing health condition, a health condition that is new but is exacerbating an existing disability. So, for example, somebody who suffers from anxiety, if they have a diagnosis of a serious physical condition, that may exacerbate their anxiety, and they may need extra support to be able to return to work or to remain at work potentially during treatment. So on the screen there, you've got the definition of disability from the Equality Act. An employee has to meet every part of that definition, but what I would say is it's a pretty low hurdle, which is why, as Emma said earlier, unless it's very obvious, such as a cancer diagnosis, then we suggest that you work on the assumption that they are covered, but don't admit that during the internal process. Only the tribunal ultimately can make a definitive finding as to whether somebody is disabled or not. So when you're managing an internal process, you have to proceed on the basis of assumptions unless it's clear, as I said. Now, the key to unblocking any situation of long-term sickness is to really understand what the issue is with the individual, what's keeping them off sick, and you're really going to need medical evidence on that. So you want to understand the prognosis. How quickly will they be able to come back? Will they be able to come back at all? Is it a phased return with or without adjustments? And once you've got your medical advice from your employee's GP, or perhaps their treating consultant or occupational health, then as Emma said earlier, what's really essential, and again, a very common pitfall here, is not acting promptly enough on the evidence. And then by the time you come to make a decision, it's gone stale. I also wanted to flag here that if you are going to be getting medical reports or information from the employee's treating physician, so their GP or their consultant, then there are additional safeguards in terms of those reports, in addition to consent, which you're always going to need if you're getting medical input. So moving on to the first scenario in long-term sickness, you've got somebody who's been off with long COVID for several months. Now, how do you manage that? Well, hopefully the line manager's been in fairly regular contact with them. But as Emma said, unlike in short-term persistent absences, where initially you may be thinking, is it conduct, is it genuine sickness? Clearly there is an issue here that is genuinely sickness, and warnings aren't going to help. It's the key, as I said earlier, is understanding what the medical position is and the prognosis. Now, with a condition like COVID, which is newly emerging, or with some other rarer and unusual conditions, sometimes you will need to go to an independent specialist or the individual's own specialist. But if they don't have one yet, then finding the right person can be tricky. So you do need to be mindful of that and factor that into dealing with the process. Sometimes, of course, we see employees not being cooperative in getting that information. And in that situation, you need to be explaining to them that you really do need the full picture in order to make a fair assessment of the situation, and try to persuade them that it's in their interests to let you have the report. And they need to understand that if they don't, you'll have to make a decision at some point on the information that you have available. Now, the medical advice might come back and say that, in a few weeks, with some adjustments, they can return to work. So in that case, you agree a plan with them, you take notice of the medical advice, and you implement that plan, hopefully. But what if the prognosis is unclear? What if there are queries in the report that you want to go back on? Well, you're perfectly entitled to follow up with questions if it's not clear, but sometimes it just won't give you the clarity that you need, and you need to make an assessment on the basis of the information that you have. And the point at which it's going to be fair and justifiable from a disability discrimination perspective to press the button and dismiss somebody is going to vary, because it's going to be very fact specific. But it will take into account the sort of factors that Emma talked about in the short-term scenario, so size of the employer, the impact on the business, etc. And what I would say in terms of impact on the organisation, in some cases it will be very obvious. And if you end up in a tribunal will accept at face value what you're saying, that there was an obvious impact. If it's somebody very senior who's absent for many months, for example, but don't assume that. So in your internal process, make sure that you are documenting and having it explained, certainly in the final meeting with the employee, if not before you dismiss, what the impact is and why it's no longer sustainable for you. The other really important thing before you make any decision to dismiss is to make sure that you've exhausted alternatives. Now, that may be alternatives in the sense of there might be another job they could do. Perhaps they could go to part-time work. Perhaps they could give up some element of their job temporarily or permanently. And really importantly, you need to look at whether you've got a permanent health insurance policy that they could benefit from. Or even ill health early retirement or other retirement options under your pension scheme. If you don't take those steps, you're much more likely to lose a claim for it to be an unfair dismissal, but it can also be a very expensive mistake, particularly if you cut across a PHI policy with its very valuable benefits. And moving on finally to the second and last scenario, I can deal with this one much more briefly. So here you've got somebody who's got a history of anxiety and depression, and that's being exacerbated by you're asking them to come back to the workplace after perhaps a very long period working from home exclusively. So many of the considerations will potentially be the same, but before you get into getting medical advice and all the things I talked about in terms of the first scenario, the key here is really to have good communication and conversation with the employee to really try and understand what their concerns are. Is it about the commute? They don't want to get on public transport. Is it about the COVID compliance measures in the office? So you really need to understand what the concerns are, because then you can start exploring with the employee collaboratively what you might be able to do to unpick them. So if it is a public transport concern, maybe you can offer them staggered work times. They could come in later, leave earlier, whatever it is, make up the time at home. They could perhaps work from home part of the week. But unless you understand what it is that's driving the anxiety and the concern, you can't really come up with effective solutions. And as I said, eventually it may be that you need to kind of go back or progress to getting medical advice and try to unpick it that way. So that's the end of the presentation. We've got time for a couple of questions, or a few questions before we close. Emma, I can see there's one here about asking about the new proposals that the government's mentioned about sort of overhauling the SSP system. Do you want to pick that one up?
Yeah, sure. I think it's fair to say that the current legislation that we've got on SSP is complicated, cumbersome, and ripe for reform, to be honest. And the government has recognised that. So they did launch a consultation a couple of years ago now, putting forward some helpful proposals of how to shape things up for statutory sick pay. So we're looking at things like simplifying the rules and widening eligibility requirements, and also looking at things like enabling non-disabled employees to return to work on either a flexible or phased basis. It took a couple of years for them to respond to that initial consultation, and we did have the response this year. Unfortunately, the vast majority of those proposals were rejected. I mean, the response was that given COVID, now didn't seem the appropriate time for a major overhaul of the system. We do expect, though, a white paper on this next year. So I think whilst nothing immediate is happening on this, it's something to watch out for, and that will be hopefully coming down the tracks.
Okay, thanks, Emma. So there's a question here about not understanding the difference between there being no statutory right to sick leave, but there is a right to sick pay, and saying, well, doesn't the right to sick pay automatically give you a right to sick leave? It doesn't, although it does seem counterintuitive. The point is really that when you're looking at the level of absence that's sustainable and whether an employer can dismiss, that's where it kicks in, that there's no right to be off sick, there's no right to have a certain level of sickness. So we sometimes see in unfair dismissal cases where the employer is basically saying, look, we're going to be moving to dismiss very shortly. The individual says, well, you can't do that because I've still got X amount of months of company sick pay left. Well, that isn't necessarily a determining factor. So that's really how there is a difference. But once somebody is on sick leave, then the rights to sick pay kick in. There's a question here, Emma, about differentiating between how you treat an employee who gets COVID even when they're vaccinated and an employee is refused to be vaccinated. Do you want to pick that one up?
Yeah. So I think you'd need to be very careful about that, because there may be legitimate reasons why an individual has been exempt, for instance, from having a vaccination. And then that brings up risks of discrimination. If that individual has a protected characteristic, it might be that for disability related reasons, they've not been able to have the vaccination. They might have phobia of needles or something like that, or there might be religious related reasons for why they haven't had the vaccination. So what I would be saying is I'd err on the side of caution and be careful if you're looking at doing that and differentiating.
Yeah, that's right. So we haven't got time to answer all of the questions, but as I said, there are a few we haven't got to, but we are up to our allotted time. So we will come back to you, provided you've given your name, which I can see most of you have. We'll be able to do that after the webinar. So I hope that's been helpful. Thank you very much for joining. And again, as I said, we will be circulating a questionnaire after the webinar. Please do take the time to fill it in. And otherwise, thank you very much and enjoy the rest of your day.
Thanks, everyone.